As you can see, we're under some time constraints, so I'll be seeking unanimous consent.
Nous allons commencer, donc je vais demander le consentement anonyme avant que les cloches ne sonnent. Numéro 2, j'aimerais faire adopter le rapport du sous-comité et j'aimerais que le budget soit adopté. Et j'aimerais aussi avoir certaines indications pour celles et ceux qui sont ici, de savoir si vous allez être présent pour l'événement avec le ministre le vendredi 10. Donc voici ce que je souhaite faire, mais je ne sais pas trop ce qu'on va réussir à faire.
The regulations with respect to these earpieces, and because this is new, but still important to prevent disruptive and potentially harmful audio feedback incidents. All earpieces have been replaced by a model which reduces the probability of audio feedback. All unused earpieces will be unplugged at the start of the meeting. If you're not using it, please put it face down in the middle of the sticker for this purpose. Please consult the cards for guidelines, and the room has been adjusted, as you can see. So there's a lot of space. I can barely see our witnesses' names, but this is the new reality. With that, I'm going to invite Mr. Defense to speak on behalf of the Privacy Commissioner of Canada, privacy. But regardless, you're very familiar with this committee and all committees on the Hill, and I just wanted to take note that over the years you've been very generous with me, and I just appreciate that courtesy and that competence. So, sir, you have 5 minutes.
Thank you, Mr. Chair, members of the committee, for this invitation to appear as part of your study of transparency within the Department of National Defence and the Canadian Armed Forces. I'm accompanied by Isabelle Gervais, Deputy Commissioner of Compliance from my office. As this is the first time that I've appeared before this committee, let me begin by discussing my role as Privacy Commissioner of Canada and the role of my office, which we refer to as the OPC. As Privacy Commissioner, my mission is to protect and promote individuals' fundamental right to privacy. This includes overseeing compliance with both the Privacy Act, which applies to federal institutions' collection, use, disclosure, retention, or disposal of personal information, and the Personal Information Protection and Electronic Documents Act, or PIPEDA, which is Canada's federal private sector privacy law. À titre d'agent du Parlement, je relève directement du Parlement.
As an agent of Parliament, I report directly to Parliament. Through written submissions and appearances such as this one, I provide analysis and expertise to help inform Parliament's review of evolving legislation and recommendations on privacy issues. The Privacy Act defines personal information as any recorded information about an identifiable individual, including a person's race or color, religion, age, marital status, as well as medical, criminal, or employment history, or social insurance number, among other data. The Privacy Act provides individuals with the right to access the personal information that the government holds about them and to request corrections to that information when necessary.
This investigates complaints that are made against federal institutions under Section 29 of the Privacy Act, which includes cases where individuals have been refused access to their personal information or instances where the institution is taking too long to respond to a request. My office also investigates issues relating to the protection of personal information, such as allegations of improper collection, use, disclosure, retention, or disposal of personal information, and this includes matters involving privacy breaches. While I'm responsible for oversight of the Privacy Act, my colleague, the Information Commissioner of Canada, Caroline Ménard, who also appeared before you on this study, administers and enforces the Access to Information Act. The two pieces of legislation were enacted together in 1983 and are intended to be a seamless, quote, seamless code of informational rights that carefully balance privacy and access. The Privacy Act has not been significantly updated since it was passed 40 years ago. The Justice Department published a consultation paper in 2021 and is still consulting on Privacy Act reform. One of the issues that it discusses is the government's approach to transparency. I support the enhancements to transparency that are proposed in the paper, and my office has made recommendations for future improvements. Transparency is important for empowering citizens with the knowledge that they need to exercise their rights and for requiring the government to be accountable for its handling of personal information. These are critical aspects of a meaningful data protection framework. En ce qui a trait à l'étude de votre comité sur la transparence,
With respect to the committee's study of transparency, my office has had ongoing engagements with the Department of National Defense. In the past 5 years, the department has consulted the OPC on a wide range of privacy-related issues, such as biometrics, open-source intelligence, staffing, and recruitment. My office has worked with the department and Canadian Armed Forces to provide advice on compliance with the Privacy Act. My office has accepted nearly 300 privacy complaints against the Department of National Defense and the Canadian Armed Forces over the last 5 years. More than half of these were related to the time that it was taking them to process requests for access to personal information.
OPC received 10 breach reports from the organization, which are primarily related to unauthorized access, unauthorized disclosure, and the loss of personal information. I welcome the efforts that the Department of National Defense and the Canadian Armed Forces have made towards privacy protection, and my office remains available to provide support and advice. I encourage them to prioritize timely responses to requests for access to personal information and also to undertake privacy impact assessments before onboarding new programs and processes. And with that, I will be happy to answer your questions.
Thank you, Mr. Dufresne. We'll start with Mr. Kelly. Colleagues, if there's any chance of getting into a second round, I'm going to have to cut back the first round, so we're going to go at 4 minutes for the first round, and then we'll go from there and see how far we can get. Thank you. Mr. Kelly, 4 minutes.
What do you consider an acceptable time frame for a privacy request related to a sexual misconduct case?
Well, it's all context-based. The legislation talks about a 30-day period for response, and then there is a possibility of extension for another 30 days. And so we would look at those cases on a case-by-case basis.
Okay, well, on April 17th, we had a witness that told this committee that complaining to the Information Commissioner and the Privacy Commissioner is not an exception to obtaining information. It's part of the process. You will not get your information unless you make a complaint. So it was put to the committee that delay is commonplace and that the department will delay and force the applicant to complain. Any comment on that?
Well, as I've indicated, a number, I think the bulk of our complaints that we receive deal with delays to the process in terms of access.
Okay, so is this a failure of leadership to ensure that information is that openness and proper disclosure is actually done?
Well, what we see is that there are many cases where the delays are greater. We work with the departments. We deal with the complaints. We found that departments were collaborative in the complaints process as they work with us. But that is an important part of the number of complaints and volume of complaints that we receive. We try to resolve them as early as possible through resolution and expedited complaint mechanisms.
All right. Well, do you agree? The Information Commissioner in her report mentioned that senior leadership is key to influencing the corporate culture change to actual compliance and timeliness under her act. So we're now two defense ministers into later. This was a 2020 report. And we hear the same complaints of slow service, intentional avoidance, a culture of secrecy that appear to apply to requests under the Privacy Act as well as the Information Act. Do you agree that ministers must see it as their, and this is in her words, see it as their responsibility to champion a new approach and to adopt these tools and practices in order to effect the necessary changes within the department?
I agree that leadership is important, and I agree that access to information, privacy are fundamentally important legislation, and so they should be prioritized.
Okay. We also heard from the same witness, Patrick White, on April 17th, that a significant barrier and challenge is that you're required to name the individual record holder in trying to get access to your information. So he equated this with the equivalent of trying to get a tax assessment from the CRA, and being required to have the employee ID number of the actual employee that may have handled it. Do you have a concern around privacy and the level of information that the applicant for information needs to get information about themselves?
Well, I think that the department should make efforts to make the system as user-friendly as possible. And one of the themes I've been pushing in terms of privacy in all aspects is really making sure that we are not delegating to individuals and to citizens.
Is the system now user-friendly?
Well, I think we're seeing in the system lengthy periods of time, and so that's something that
Periods of time for delay.
Thank you, Mr. Kelly. Mr. Collins, 4 minutes.
Thanks, Mr. Chairman, and welcome to our witnesses. In a perfect world, we'd have perfect compliance with the legislation and the acts as they exist, and of course the world isn't perfect, so we have people who are not in non-compliant situation. Can I ask, in terms of the education and outreach services that your office provides to those in CAF or elsewhere, to ensure that people are properly trained, and when someone is making their way through the system, they're actually following the rules?
So that work really is done, I would say, by my office and by the Treasury Board Secretariat. Treasury Board Secretariat will be providing guidance and information to the departments themselves, and in terms of best practice and expectation. One example of that is the directive on privacy impact assessment that I would hope to be made a legal requirement, because right now it's something that is in Treasury Board policy, but it's not in law. So they play very much that education role with the department. We work with Treasury Board. We are consulted by Treasury Board, and we would want that to continue and to increase, so that our perspective informs the Treasury Board directives and the Treasury Board training that they will do. We have a government advisory services within my office that is available to assist and to provide input on to departments for new programs, for initiatives, and to be consulted on privacy impact assessment. So, but certainly we are doing that in tandem with Treasury Board Secretariat.
The committee's received a lot of recommendations in terms of constructive criticism as it relates to improving the system and how it operates. You must deal with your provincial counterparts. Anything to learn from their acts that in many instances are they've been updated, they're not 40 years old. Can you provide to the committee recommendations in terms of what we can learn from some of those other jurisdictions within Canada that have made improvements?
Well, I think one of the improvements certainly that I would like to see in the privacy legislation, both the public sector and private sector, is order-making power. That is something that Parliament has given now to the Information Commissioner in terms of access requests. That was a positive step in Bill C-58. It is something that's currently proposed in Bill C-27 for private sector privacy legislation. I would want this to be part of public sector privacy legislation. That was one of the recommendations in the Justice Canada paper. Specifically with respect to access matters, I would want this to be expanded to all matters. I think that this is an area where some of our provincial counterparts and indeed our international counterparts are ahead, where the authorities, my counterparts, have the ability not to make merely recommendations, but also orders. So that's one area. I would be remiss if I didn't highlight the very strong collaboration that I have with my federal, provincial, territorial counterparts in this space, and this collaboration has led to joint investigation, joint statements and resolutions. So we're going to continue to work very closely with them.
Thank you. You talked about privacy impact assessments at the end of your statement, but you didn't elaborate on those. Can you highlight what they are and the importance of them?
So privacy impact assessment is really a due diligence tool where the organizations that's thinking of putting in place a new program, a new tool, something that can have privacy impacts, is required to assess those, assess the impacts, look at the risks, document them, think of solutions to mitigate those risks, and to do that in consultation with my office. And so it's a very powerful tool. It's a good practice, and it's good for everybody. It's good for citizens who are going to have better privacy protections. It's good for the departments because they get advice, and they're seen to be getting advice from a neutral regulator. So this is absolutely something that should be done in all cases and before the new tools and the new programs happen. In reality, that doesn't always happen, which is why it should be a legal requirement in my view.
Thank you, Mr. Collins. Madame Normandins, 4 minutes, s'il vous plaît.
Merci beaucoup. Merci.
Thank you very much. Thank you, Mr. Dufresne, for being here. Madame Gervais as well. I have a question for you, Mr. Dufresne, with respect to something that I've already asked in a previous meeting to other witnesses. From some force, I've heard from some members of the forces that when something ends up in their file, if someone accesses their record, it's not indicated anywhere who actually took a look or had access to the member's record. Is that something you're aware of? That specific example is not ringing a bell for me. For you, no? If that were the case, to you, would this be an issue that you could be responsible for or that would fall under the Privacy Act? I think about, let's say, Véronique Cloutier on health with respect to her own health record. 300 people had accessed it. Perhaps someone who could have access to this complaint if this actually is an accurate fact. One of the issues is this. What was the reason why that information was obtained? It needs to be a legitimate purpose. It has to be in relationship with the organization's mandate, and you have to protect that information. You can't disclose it with no grounds, and you have to think about the basic underlying grounds, and that's the basic issue. If you access information for legitimate purposes, not all of government needs to access this information. It has to be related to the legitimate purpose. And if you transfer that information or don't protect it sufficiently, then you can end up in situations where there is a privacy issue. Thank you very much. In another vein completely, I'd like to hear about what you think about artificial intelligence in this sense. I hear you've done some work on ChatGPT, some research, and how users' data is used, shared, etc. The department says that CAF will be turning to AI increasingly in the future. We see that in the U.S. Agreements have been signed with Amazon and Google. I'd like to hear what you have to say about potential risks in having the Army access or use AI when it comes to privacy data or of military personnel and others. Actually, yes, we actually currently have a joint investigation with our colleagues from BC, Quebec, and Alberta on the issue of ChatGPT, and that's ongoing. We've also issued a statement along with our colleagues from the G7. There's regular conversations going on about this ministerially, but also among privacy commissioners. And we issued this statement on AI. And yes, we need new legislation. We need to modernize legislation, sure. But we have acts that exist, like Privacy Act, and among the colleagues at the federal and provincial level, we issued a statement in December, and we issued the principles that we would like to see protected in terms of privacy in AI. The issue of consent, legitimate authority, rigor, security or safety, thinking about the impacts of using that kind of technology. It's not specifically under our mandate, but also the issue of discrimination. So yes, there are many benefits to using AI, but there needs to be a framework for its use. My colleagues at the CRTC and the Competition Tribunal, we've created a group for these types of regulatory agencies to work on these issues because we're going beyond privacy, beyond issues of competition or discrimination. So there needs to be close cooperation on even issues of national security. So this is an issue that matters to us, and it's one of the strategic priorities, certainly. Thank you, Madame Normandin.
It's Ms. Mattson.
Thank you for joining us today. So earlier in this study, we heard from Michael Drapeau that when CAF members are filing grievances and cannot access their information, your team are in place. This is the only place that they can access some of that. You mentioned it before in terms of the fact that so many of the cases that you deal with are in fact that lagging behind in terms of being able to get information. But even the investigations that your office can take on, they take about a year or so, which creates a lot more delay in terms of that pursuit for information and on their grievance. Can you tell us where the delays are created and what's being done, if anything, by D&D CAF to improve that?
So I can tell you certainly we are seeing throughout this issue of delay as being an important one to tackle, and ourselves as well, the complaints, the process that we have. So we have put forward as one of our strategic priorities the notion of looking at our own processes to see can we make those more efficient. We've obtained resources from government and parliament in terms of dealing with backlog cases, prioritizing certain cases, looking at our process to see are they as efficient as they can be, are there things that need to be changed, and that should be done by departments as well. And that's where putting it as a priority, making sure that you are challenging your processes, you're removing inefficiencies, you're making sure that these things can proceed efficiently is certainly very important.
The Deputy Minister of Defence, he said that the department was doing that. Is that, in your opinion, the case?
Well, I can speak about my office, and as then we are still seeing some complaints with time limit complaints. That is a big proportion of that, and so encourage D&D and all departments to continue their efforts in that.
Okay. I have a bill, C-362, which creates an independent civilian oversight agency within the Ombudsman's office for CAF D&D. Many witnesses have supported this, former ombudsmen have supported this, and the reason for that is the need for investigative bodies to have more teeth. And as you had mentioned that before, certainly this can be very, very helpful. The department refuses sometimes to disclose information, whether it's to CAF members going through the grievance process or veterans or journalists or researchers. The department will only disclose this information when your office, as Mr. Kelly had mentioned, that it's only when your office gets involved that they can get anything. Can you talk about the teeth, I guess, in that your team has on that investigative powers piece, and whether you believe that more is necessary for the independence in that role within the offices?
Oh, absolutely. And as I said, we are working with departments, both in the complaints side and in the guidance side and the promotion side. And there is good collaboration. But the reality is we do need to have order-making powers and to have binding authorities. It just assists, and it's not because I want to issue those orders, but the mere existence of that possibility tends to focus the mind of decision makers, and it helps to prioritize efforts in those aspects. And so this is why it's very important that my office be given these order-making powers, both in the private sector and in the public sector context.
Because ultimately, when you do find that there's a breach, what happens?
Well, we'll investigate it, we'll make a finding, we'll make recommendations. And in many cases, the recommendations are followed, and that's a good thing, but not always. And so that's where the order-making power comes in. Or in the case of privacy impact assessment, it's required in Treasury Board policy. It's there. It has to be done before the program is launched. We have to be informed. We have to be consulted. It doesn't always happen, or sometimes it will happen after the program has been launched, which creates more risk for everyone.
Thank you, Ms. Mattson. If the clerk and my math are correct, we still could get another 4-minute round in. And if we don't, it's the clerk's fault. And if we do, it's still the clerk's fault. With that, Mr. Acheson, 4 minutes. Allison. Yes.
All right. Thank you, Chair.
Yeah,
And
only known
thanks,
of your 20
thanks to our guests for being here today. So I guess my question is, how would you rate the job that D&D or CAF are doing, based on the fact we got over 300 complaints, the number of days, et cetera, delayed? So how would you describe D&D and CAF? Would you describe them as being transparent and a good example of a compliance department?
So we have statistics in our annual report in terms of the number of complaints that we received versus departments. So there's certainly among the higher ones with the higher number of complaints. We have received good collaboration with them, and we're working with them to resolve these cases early. But in terms of the numbers of complaints, I think that on the list, they would be fifth on top of the list in terms of the number of complaints that we've received.
All right, top 10, okay, there we go. What about individuals that get a tip sent back as deemed refused? Like, what are their options? I mean, it's deemed refused, so how do they respond?
Right. Well, their option is to go to federal court. So the legislation provides that at that stage, individuals can exercise those rights. So this is the importance of that determination that we make. It opens up that recourse for federal court.
So that almost seems almost impossible for an individual to be able to go to court to do that, correct?
Well, it's something that they have to do. The onus is on them to do that.
So that's the only option. Go to court and incur some kind of costly legal battle to do that.
To have enforcement, again, which is where the recommendation for order-making powers to be able to have a decision that will be binding is something that we've been recommending.
Okay. I guess I got a question. Does the Privacy Commissioner have the same legal authority when it comes to taking the D&D to court, like it would in terms of the Information Commissioner? What type of powers would you have in terms of being able to deal with that?
Well, we have important powers in terms of the ability to obtain information from the departments as part of our investigation. So we can do that. But the power that we lack is the power to issue a binding order at the end of the investigation when we make a finding. If we make a finding that the legislation was not complied with, we make a recommendation. We don't make an order. And so that's this critical difference. In the context of, there are also some who argue for there to be financial consequences, fines and so on and so forth, and that's something that's being proposed in the private sector legislation that's currently being debated in committee. But for the public sector, certainly at a minimum, having this order-making power would, in my view, make the process more expeditious, because you would have the investigation by my office, by the regulator, and then you get a decision, and then that decision is binding. And so instead of having the individual have to go to court and take those steps, that order applies, and then it would be up to the department to challenge that order in a court process.
Okay. I probably got time for one more question here. Do you think it's... What's that?
30 seconds.
Okay, perfect. Do you think it's reasonable for a requester, whether they be a junior member or a vulnerable person, to be able to actually name, specific record holders? I mean, the challenge is they go in, they need to know who's touched the file. How on earth would they ever be able to do that? Would it be an easier process for them to be able to get that information?
Well, I think that the process, I don't have a specific area on this other than to say that the process should be adapted to the circumstance, and the process should be as user-friendly as possible. If you make a process and it's very challenging, or there are disincentives for individuals to use it, that's a concern. And so the processes should be looked at. There may be specific realities in specific departments, but the idea is make this process easy to understand, easy to use, so that those rights can be exercised.
Thank you, Mr. Allison. In anticipation that the bells are going to start ringing shortly, do I have unanimous consent to proceed 15 minutes after the bells? Okay, thank you. Mr. Fillmore, 4 minutes, please.
Thank you very much, Chair, and thank you, Mr. Dufresne and Ms. Gervais, for your work and for your time and presence here today. I want to begin by speaking with you about modernization and digitization. And I'd like to just briefly at the beginning explore a question that I've asked some other witnesses on this study, and that is, sometimes we can fool ourselves into thinking that going entirely digital and relying entirely on computing to streamline and simplify and expedite processes is the way to go. In the case of your work, would you say that's true? Is it necessary to become entirely digital?
Well, in the case of our work, we're looking at a range. We're looking at it's not entirely digital. We're doing some combination of both, and we've created a tool, for instance, where for the breach, if we assess whether a given privacy breach is a real risk of harm, we've designed a digital tool that's going to give an opinion on that and assist in that. So there's a combination of that, but then you're going to have the assessment by the investigator, and you're going to have those decisions. So I think we always have to have that in mind. Digital and technology bring significant advantages. We need to harness those advantages, and we also need to manage them so that there aren't implications that could harm privacy or other aspects.
Okay, thank you. I think you began to answer my second question, which is what initiatives do you have underway now to modernize and digitize your work within the Commission?
So we've moved forward in terms of information on the cloud, for instance, at the OPC. We are looking at technologies generally to see which ones could be used, how to use them. In terms of our strategic priority, we talked about staying ahead of technology in terms of legal compliance. What that means is we have a role as a regulator to provide guidance, to make decisions in terms of complaints on new technologies, including artificial intelligence. But also, as an institution, we have a responsibility to be as efficient as possible. So if there's technology that can help us do that work better, we have to consider that, but we have to consider that in a way that is privacy protective and in a way that can serve as an example to say, well, if you're going to use this technology, here's the type of due diligence that you need to do before you use it. One of the messages we've been giving to government departments is before you use new tools from a private sector organization, make sure that you do that due diligence, that you have the privacy impact assessment, and that you're satisfied that this technology is protective of the privacy of Canadians.
Okay, well, so this is interesting. You really do walk a line in your office. On one hand, you're compelled to be open and transparent, and very much about providing information in a free and open way. But at the same time, you need to protect privacy and protect people who deserve and need to be protected. You mentioned, I think a moment ago, you've developed a digital tool that helps to de-risk that, and I think we've already heard someone mention AI. So is the computing power able to? Are you using AI in cases like that in the tool you mentioned?
Well, the tool that we've developed is a tool where you will input the types of informational elements about the breach, what happened and in what context and so on, and then that tool will generate a score that will say, well, this looks like it's serious enough. This looks like something that you should be reporting a breach. So it's designed to help. It doesn't replace the expertise and the human decision-making, but that's an example of using technology for something that can help privacy. Other examples of privacy-enhancing technology would be synthetic data or other types of information where you can use technology to protect privacy. So you can achieve the same benefits of data without being able to identify individuals. So we're looking at all these spheres, but as you indicate, we have to make sure that whatever we're using, we're doing it in a privacy-protective way.
Thank you.
A very tight 2 minutes, Ms. Normandin.
J'aimerais continuer sur la question des évaluations.
Thank you. Let's keep going with aspects affecting privacy. I'm sure you're familiar with Cellebrite, which is a tool that is used in part by CSIS and DND. Despite the fact there is a judicial authority for it, an internal investigation, there is the issue of knowing if the government doesn't do what it's supposed to be doing in this case, it's actually in violation of its own legislation. So what needs to be changed? They're not actually contravening their own act because it's not an obligation under the act, and that's the issue that we've identified. There should be this obligation in the act. stating that when a department develops a new program, use new tools that could have a significant effect on privacy rights, then there should be this evaluation done. At this point, it's a directive on the part of the Treasury Board. So the department that doesn't comply has violated the directive, but that's not legislation per se. And we'll continue to encourage departments to do this. We'll continue to call for legislation that would make it mandatory, and there's important work that's done by the media, by parliamentary committees to actually raise these issues. But in an ideal world, when it is raised, the answer should be or would be, yes, we've done that. We've done that assessment. The idea is not to say these tools are prohibited across the board. No, I mean, police forces need the necessary tools, but it needs to be done with some degree of discipline and carrying out those privacy assessments. We rendered a decision with respect to the RCMP and the use of some tools that they were using to fight crime. Of course, it's important. They need to achieve their mission. But we identified that the approach taken was not enough. So we continue to do that in the context. And with a legal obligation, I think we would see more compliance.
Ms. Madison, also a tight 2 minutes.
Okay. In a previous meeting, we heard from witnesses about the still unresolved Afghan detainees case. Government had prorogued Parliament before public had a chance to learn the full truth of whether the government was knowingly transferring Afghan detainees. And we wouldn't have known that without specific whistleblowers and the protection of those whistleblowers. Richard Coleman was the diplomat who brought the allegations forward, and we heard that, of course, senior military leadership, government, elected officials, they were involved. They tried to discredit him. There was a lot that was done against that whistleblower, and there weren't protections in place to ensure that he, at the time, was protected. So I want to know if you believe that there have been enough legislative changes to effectively protect whistleblowers, because we certainly heard in this committee as well that through chain of command, if things are brought forward, there is often punishment for that. So can you talk about that in terms of what you've seen and your experience as the commissioner?
Well, I think that it's important that people be able to access legal recourses. If you have a legal right, if you're protecting citizens, employees, civil servants, or otherwise, people need to be able to access the systems. People need to be able to file a complaint and not worry about repercussions or reprisals. And so from my standpoint as a regulator, that's important. It's important that you're not creating these disincentives for individuals to file complaints, because at the end of the day, this is all being done in the public interest and with the mandate of Parliament.
Thank you, Ms. Madison. Mr. Bassan, 4 minutes, please.
Thank you, Mr. Chair. And just want to, just for clarification, Mr. Dufresne, you talk about that your office was created in 1983 under PIPEDA. And that's the same bit of legislation that was used to create the Office of the Information Commissioner as well, correct?
Not PIPEDA, the Privacy Act.
Privacy Act, okay.
Yeah.
But the Information Commissioner has the power to take the Department and the Minister of National Defense to court for failure to comply with the access to information.
That's right. So Information Commissioner created under the Access to Information Act, Privacy Commissioner under Privacy Act, and more recently, I think it was 2017, I may be wrong on the date, but C-58 amended the Information Act, the Access to Information Act, to give the Information Commissioner order-making powers. And that's something that has not been done yet.
So you don't have the ability to hold the department, the minister, the assistant deputy, or the deputy minister, or the chief of defense staff accountable for failure to comply with the act?
Not through a binding order. I can certainly, I will not minimize the impact of a public ruling, a public recommendation, and also the role of committees and so on. But I don't have the ability to issue a binding order. Okay,
so that's one of the recommendations that we should be looking at. The other part of this is, do you think, and you mentioned it, that then people wanting to get access to their privacy, their own records for their own needs at Canadian Armed Forces or the Department of National Defense, they have to go to court. Do you think that's fair for one person to take on the entire Department of National Defense?
Well, I think that the more efficient an accessible system is one where you can have a regulator issue an order. And so that order then is binding. And again,
Happening right now.
we don't have that right now. And also, having the possibility of an order makes it more likely, in my view, that you're going to get early resolution of the matter without having to go through the whole process.
So we've heard from multiple witnesses already, including the Ombudsman, the former Ombudsman Gary Walborn, Mr. White, Mr. Drapeau. There is a culture of overclassification within the Canadian Armed Forces and Department of National Defense. Do you think that's done to intentionally hide records from their own members of the Canadian Armed Forces and veterans?
I don't. I think that the legislation provides certain exceptions for disclosure, either under my legislation, Privacy Act, or Access to Information Act. And so departments have leeway with that. There's some valid public interest reasons to prevent disclosure, or both under legislation, but the recourse exists to challenge those.
Yeah, I'll give the rest of my time to Ms. Glant.
She's a little over a minute.
So how often are the military personnel system records audited for unauthorized searches?
I have statistics of the complaints we received at my office. So we would receive complaints directly from Canadians, and I've indicated that I think in the last 5 years we received 300 complaints.
All right, so what is the privacy policy with respect to military personnel health records and access to those records by VAC?
Access by VAC, there is some exchange of information between the two institutions in terms of those types of records. We have been engaged, we've been consulted on that. We understand we've received some PIAs, Privacy Impact Assessment on that.
Right, so troops returning from a deployment on commercial aircraft had to complete the ArriveCAN app. We know that the disclosure allows the app to share information to contractors working for Public Health, Service Canada, provincial, territorial, municipal, and may be used for program evaluation and other organizations. Do we know whether or not any of our troops' personal information, their health information, was shared with commercial companies, state-owned enterprises, shared with anyone at all outside our government?
Very briefly, please.
We are currently investigating the ArriveCAN app following complaints, so I won't be able to speak further on that as this is ongoing.
Thank you, Ms. Gallant. Ms. Lamoropoulos, final 4 minutes.
Thank you, Chair, and thank you, Monsieur Dufresne, for being here with us today. I'm wondering if you could tell us, like, based on the complaints that you've received and the fact that some of them take a really long time to receive a response or to get their cases dealt with, what do you think would make the process more user-friendly? What is it that you think would help facilitate things or make it more accessible to people?
Well, I think that the resources and the efforts have to be put in making the system as user-friendly as possible. I think there are a number of modernization recommendations that need to happen in terms of making the system, the principles more up-to-date. An order-making power is one. Mandatory privacy impact assessment is another. There are some definitions perhaps need to be updated as well. But I think one of the things I've been highlighting since I've started in this role is the need to treat privacy as a fundamental right, speaking for the privacy purview. And so giving it that priority, making sure that these matters are seen for what they are. This is individuals looking to have fundamentally important information about themselves. We need to make sure the system is accessible.
Do you find that the way that the current system works, it is easy to understand for all users?
I think we can make it easier to understand, and I think we can make it faster. I think we are seeing that in terms of the statistics, and so that's something to be working towards.
And sorry, how do you measure success in your work? How would you say you measure success, and what do you think could be done to improve your? I guess what shortcomings are there, and how can we improve them in general?
Well, I think we're measuring success by looking at the statistics, by looking at the trends, by trying to see, are the number of complaints increasing? Are the number of complaints that are being resolved quickly? Are the timelines decreasing? Is the collaboration that we see, the exchanges with the departments, when we're thinking about privacy impact assessments, are those being done before new programs are started? Are we being kept informed? Are we being consulted? All of those things are elements of what we would look in terms of success.
That's it for me. Thank you.
Thank you. Well, on behalf of the committee, I do want to thank you both. Both of you are very sophisticated witnesses and know the time constraints that we have on committee, but thank you for your testimony. Appreciate you appearing under the circumstances. So, colleagues, before we gavel to an end, may I have Mr. Bazan move the subcommittee report? Ms. Lalonde will second it. Any debate? Seeing none, adopted. And I'll ask Mr. Bazan to move the report of, was it, how much money? I can't read it without my notes. 16,500 for the Defense Committee report. You moved, you seconded. Any debate? Seeing none, thank you very much. And finally, if you could indicate to me whether you will be available for meeting with the German Defense Minister on Friday, the 10th, at what, 12:30?
It's 12:15 now.
12:15, yes.
You'll be here?
So I've got one Conservative, one NDP, one. Okay, with that, thank you. Appreciate the cooperation.
12:15.